My name is Amy Perry, and I'm an adult service specialist with Gwinnett County Public Library. Thank you so much for joining us this evening. Tonight, we have a pleasure of having the Georgia Department of Community Affairs speak to us about the Fair Housing Act and how to go about making a proper complaint if you feel like you've been discriminated or other issues with the Fair Housing Act. Tonight, we have two presenters. One will be Christy Barnes, who is Director of Legal Services for the Georgia Department of Community Affairs, and Joseph Collins, who is the staff attorney for the Department of Community Affairs. And so I'm going to go ahead and give it over to Christy and Joseph. And again, if you have any questions, put them in the Q&A. Thank you again for joining us this evening.
Thank you so much, Amy. We're happy to join this evening and excited to share with all the participants some helpful information about this vital topic. As you mentioned, I'm grateful to be joined this evening with our Director of Legal Services, Christy Barnes, and we want to really try and guide everyone through a conversation regarding the origins of the Fair Housing Act and how it is applicable to your daily lives as you go about your housing searches, whether that be for rental or for purchase, and available remedies and avenues available to you should you encounter or one of your loved ones encounter housing discrimination. So again, welcome and thank you all so much for having us. Excuse me. As I mentioned, that's our team that's here in place this evening for you. And I want to start with a question that I think is central to our discussion. And that question is simply, what is fair housing? We summed it up and tried to provide a concise definition that hopefully everyone can relate to. And simply put, it means you and your family have equal opportunity to choose where you would like to live without being discriminated against or treated differently than any other person. And I think that's vital when we understand what is the foundation of this law and what was the motivation for our leaders at a national level as well as a state level to implement these protections was to ensure that everyone has adequate and equal access to a safe and comfortable environment whereby they can thrive and live and work. So as I mentioned the history, there is a history behind the Fair Housing Act. It really is a spawn of the Civil Rights Act of 1965. And around that same time, Georgia's and Atlanta's very own Dr. Martin Luther King Jr. led a movement, a housing movement out of the city of Chicago, whereby he demonstrated and petitioned the local government there in Chicago for increased rights and increased access to homes, education, as well as jobs. And I bring that up and I mention it to you because the signing there that you see in the center is President Lyndon Baines Johnson signing the Fair Housing Act. Unfortunately, Dr. King did not live to see the signing of the act as he was assassinated just 7 days prior to this signing. And President Johnson has been quoted as saying, "This is a fitting testament. All the protections afforded to individuals throughout the protected classes of the work of our very own Dr. Martin Luther King Jr." So as we talked about, it was April 11th, 1968, when President Johnson signed the Fair Housing Act and really stood up a framework to provide protections that would prohibit discrimination, as you can see, concerning the sale, rental, financing of housing based upon all of the protected classes listed there. And I won't read those now because we're going to delve into those with some detail a little bit later on. But I will say the Fair Housing Act requires the department that was developed to administer the program, as well as recipients of federal assistance from HUD, to do more than simply not discriminate. They have a real affirmative duty to further fair housing. And must take meaningful actions to overcome patterns of segregation and foster those inclusive communities that were in the design of the legislators as they crafted and enacted this legislation. You'll see here that the state of Georgia also took steps in 1990 to enact their own Fair Housing Act, and that allows for enforcement of these policies here at the state level. And I mentioned previously President Johnson's statement regarding our very own Dr. King. So let's talk a little bit about what the Fair Housing Act, provides in the way of enforcement options. First, we'll start here where it just looks at the Fair Housing Act providing prohibitions against the discrimination and the intimidation of, first, individuals in their homes, apartment buildings, and condominium developments. And I think it's important to distill that out so that everyone understands that these protections are not concentrated or just afforded to one particular group. Everyone has different housing needs as well as housing options available. And the act was intended to cover the broad spectrum of those housing options. So we mentioned the protected classes a little bit earlier, and I want to delve into those a little bit more. You know, the Fair Housing Act certainly prohibits discrimination on the basis of race, and when we hear about that often, unfortunately, and it was one of the major motivating factors for the enactment of the Fair Housing Act. But I also think these other protected classes are important to note and important to pay particular attention to. So in addition to race, we have color, we have religion, we have national origin, we have sex, we have disability status, as well as familial status. And familial status, I just want to add a couple additional notes. That, that includes children under the age of 18 living with their parents or legal guardians, as well as pregnant women and people securing custody of children under the age of 18. So again, the intent and the purpose of this act is to capture the broad spectrum of housing needs, as well as individuals who are, seeking housing at any given time. I also think it's important to note, because this unfortunately is an area where there's a lot of questions and the law is very broad in its protections here across multiple statutes. But the Fair Housing Act provides protections for other able or disabled persons. And there are these particular, and it describes it as additional protections to individuals who have physical or mental disabilities that limit one or more of their major life activities. So if you can imagine anyone with any physical impediment or disability, as well as mental, to the extent that it impairs a major life function, the protections of the Fair Housing Act are applicable to that individual. One of the things that is often not spoken about quite a great deal, but it should be lifted up, we feel, is that individuals with disabilities are permitted to make reasonable modifications to their home, albeit at their expense, but often, individuals who are seeking housing or already in place with their homes find difficulty in getting the clearance or the approval to make these reasonable modifications. And there is an obligation on the part of these landlords or homeowners in whatever instance you find yourself to petition and have those reasonable modifications approved. And that dovetails into the last point, that in addition to your ability to make reasonable modification, housing providers must also make reasonable accommodations. And the example here on the slide is a building with a no pets policy, has an obligation to allow a visually impaired tenant to keep a guide dog, because if you are in need of that particular accommodation, that is going to be a major impediment if the pet policy for all the residents won't allow for your visually impaired support animal to be in place for you. Next, I want to talk and let us look at the symbol here. Often you'll see this symbol displayed prominently, sometimes not so prominently, but whenever you find this symbol, it is a symbol signifying that this landlord or this housing provider is engaged in practices that are intended not to discriminate. They are taking their best efforts to fully comply with the Fair Housing Act. And this symbol is to be a signal to all those who approach this residence that they are engaged exactly in those policies for equal housing. And it's an important symbol to note and an important symbol to look out for as you move about, as you select your housing options, to ensure that there's an awareness and a keen focus on providing and honoring and respecting these laws. Again, what the Fair Housing Act of 1968 did, just as any other legislation, it effectively outlawed or made illegal all discrimination on the basis of, a participant's status in one of the protected classes. You'll often see the sign here, and it's not seen as much lately, but I can remember growing up here in Georgia and seeing this sign displayed in different areas. And now to understand the importance of the display of this sign is something that it really resonates and hits home with me. So in addition to the equal housing opportunity sign and symbol, you want to pay attention and look out for these symbols. There's not a firm affirmative obligation to display them in any form or another, but it certainly is helpful to those who approach from the public to see that this housing provider is committed to providing fair and equal housing. Some of the outline prohibitions against discrimination can be best summed up in a couple key phrases, but I wanted to display all of them so that anyone maybe taking notes can really make a note of these and really focus on all the different areas that the Fair Housing Act covers. So we see refusal to rent, refusal to sell, all that is prohibited, as well as refusal to make available instant negotiations for housing. I think this one is very important to make a point of, because so often the real impediments to housing and the fair access to housing is a lack of knowledge. And when housing providers are engaged in practices that ultimately result in their refusal to make available, or even in some sense into negotiation, it really serves to wall off or close out individuals' access to fair housing and adequate housing options. So it's one of particular importance, and I wanted to lift it up and highlight it for our audience here as well. The same is true for mortgage loans or to provide insurance. Our next slide really gets into some of the particulars. So if you find a pattern where housing provider is either setting different terms or conditions regarding the privileges for sale or rental of housing, that is all covered in prohibited behavior under the Federal Fair Housing Act, as well as some of those that are most prominently known listed as well, which are threatening or coercing or attempting to intimidate anyone who's seeking housing. Some that thankfully we don't have as much experience with at this time is making discriminatory advertising. However, this deserves some fair scrutiny as well, because the advertising should be, plain and as well as open to all potential eligible applicants. And there has to be a particular focus paid to the wording and the presentation of that advertising material. So that's also something to make note of, because what may seem almost innocuous to you for your particular protected class, it may not be so for another. And so the act provides, those protections, and certainly should be honored. Another key example would come down to owners attempting to persuade owners to rent or sell housing by suggesting that people of a particular race or another protected class have moved or are about to move into the neighborhood. And these are some of the more insidious examples that we see from our history, and some of those examples that this act was intended to really root out, as well as falsely denying that housing is available for inspection, rental, or sale. These are all important examples, and it really highlights the importance of there being a broader understanding about the protections that are available, so that if anyone encounters these, they're able to, really make themselves available to the remedies that are provided under the Fair Housing Act. There are certain exemptions from the Fair Housing Act. They are limited in scope, and they are with, very discrete purposes. So we'll see here as an example, homes or housing for older persons, and those protections extend so that as senior living or housing facilities really want to make sure that they're able to provide a safe environment for individuals as they age and certainly have different needs without discriminating against those from the other protected classes. It is very limited to familial status discrimination. I want to make that point as well, because all other protections remain in place outside of that particular exemption for housings for older persons. The Fair Housing Act does not cover owner-occupied buildings, with no more than 4 units, single-family housing rented or sold without a broker, as well as housing for members only. And that's a bit more of a rare occurrence, but I did want to make everyone aware of these exceptions from the Fair Housing Act, So the question may be sort of spinning around in your minds now. What is housing discrimination? If we look at it in practice, and if we're looking for concrete examples as to what does it look like, we've all seen some of the unfortunate images from our past in this nation, but today those discriminations may occur in a slightly more veiled way. And what we wanted to do in this presentation is lift up some examples to allow everyone to move away from this call and have the knowledge of how to be aware and how to really spot some of those discriminations. So for example, you may see a sign that says vacancy, but when you inquire with the manager, it is, we just rented. Now, we certainly recognize and understand that that may be a fact, and it may have just been a slip of memory, but we want to pay particular attention to that, because it was obvious, it was a tactic that was used very broadly in times before, and certainly in some limited circumstances now. You may hear a statement, or someone may hear a statement or encounter, you really wouldn't have enough space with so many children. And we can hear the latent, sort of discriminatory intent in that, as well as, I don't think your wheelchair will fit through our doors. So again, you want to have a keen awareness for those statements and have your ears aware, because this process, as we all know, is a daunting process to find safe and secure housing. And so the act, as well as all the intentions of the legislators that passed the act, want to ensure that you're not facing some of these discriminations. Move forward here. You happen to notice through a series of observations or investigations that only tenants of a certain race receive notices, or only tenants of a certain protected class that we looked at before are receiving eviction notices. You may see or notice a pattern of setting higher or lower rents or deposit requirements, or even credit worthiness for participants, of a particular protected class. And you can see how this, if a housing provider was able to pick and choose between one or several of these, you could really make for a situation where someone seeking housing may be at different rungs of the socioeconomic ladder, or who may be at different places in their lives, could present a serious impediment to securing safe housing. As well as we note here, failing to respond to inquiries by prospective minority tenants. Some of you may have been aware of some of the practices in the past where, when these claims came about, there would be an investigative period and even, a testing period where different individuals belonging to certain protected classes may go in seeking information or may submit an inquiry. And often in those examples, when the discrimination was taking place, it bore out that there was a discriminatory intent toward individuals belonging to that protected class. Some more examples are failing to inform prospective buyers. We touched on that a bit before, but I want to really hone in on it because it really does present a significant impediment. We're all very busy in our lives today, and life doesn't slow down because you are in need or in search of safe housing. So if you go and you need the quality, accurate information, and someone is failing to inform you, that is a form of discrimination. And housing providers have an obligation to provide, with reasonable certainty, all the available listings in a particular price range. Some of the others that, again, we've heard about throughout the years, utilizing tactics to avoid showing available options to anyone in a particular protected class, as well as exaggerating sales terms in order to discourage, participants, those who are looking for houses from participating in housing options in particular markets. So if you unfortunately have encountered housing discrimination and you find yourself frustrated with the process and looking for answers as to what do we do next and how do you really avail yourselves of some of the remedies of all the protections we talked about earlier, this next session of our presentation wants to discuss how you go about identifying those and making the officials who can provide assistance aware. The first thing you want to do is, I'll start at the bottom of the slide because I think it's important. You want to make note that the complaint of the alleged violation should be filed within 1 year of that alleged violation. And that may be widely known, it may be little known, but it is very important. There is a time sensitivity to these processes. Obviously, if you've encountered this type of discrimination, your need for housing doesn't go away. So the statute contemplates that you'll still need to go about the business of securing your housing. But if you're going to provide a discrimination complaint, that will need to be done within 1 year of that alleged violation. And here are some of the details that you're going to need to provide in that complaint. Certainly your name and your current address, the name and the address of the individuals engaged in the violation, the address of the housing that's involved in the particular violation, as well as a short description of what happened, what your experience was, so that, as the investigation moves forward, we can certainly document how you experienced the discrimination and certainly vet and ferret out where that took place. And then finally, the date. So as you've taken down all that information and you're looking forward to see how you may submit it, we have the option to mail in a letter detailing, including all the information mentioned on the previous slide. There's even an option to fax it in. There are online submission forms that you can complete containing all that information, as well as there's a telephone line for you to provide, that's provided for you to submit your housing discrimination claim or complaints, excuse me. This next slide, and I'll make sure that we spend some time here because it's important. I want everyone to have an opportunity to take note of the 3 options that are available here. So I mentioned before that in 1990, the state of Georgia enacted their own Fair Housing Act and really set up a structure in place to provide residents of Georgia an opportunity and an outlet to submit their fair housing claims. And if you'll see that To the left of the screen there, you submit those claims with the Georgia Commission on Equal Opportunity. Their address is there just downtown on Martin Luther King Jr. Drive. They have a phone option there. You have the toll-free option there, as well as a fax. And their website is also listed here in the presentation, where they provide online form submissions for it as well. If for another option, you have the HUD Southeast Regional Office, and that is located at Marietta Street on the 16th floor, excuse me. You have a toll-free option to place your call there. They have a local phone number, as well as a fax number, as well as a line dedicated to those with hearing impairments as well. They also provide an email address for you to submit those complaints containing all the information that we outlined before: your name, the date of the allegation, as well as a short description and the address where it occurred. And you can submit that information via any of those means. And then finally, the headquarter office of HUD provides an available option for you to submit that complaint. And you'll see all the options available there, very similar to the previous two options. And I want to just take our time in going through this slide because it is important to know. I can only imagine having seen so many of these instances, the feelings that are elicited when you feel as though you've been discriminated against. And it may be a paralyzing experience. It may be an experience where you feel as though there's not options, but we really want to convey to you that there are many options available, and these three are the best available options for you. So feel empowered as these situations, come about, that there are resources available here for you locally and at a national level. What to expect following filing a fair housing complaint via one of those three methods that we just referenced. You'll get a notification from HUD that your complaint has been accepted. They were also going to take measures to notify the alleged violator, which is why their information will be needed to submit it. And then they're going to engage in a reasonable cause investigation, and that is going to include, again, vetting your short description of what is taking place, as well as their investigators looking into all of the relevant situations and circumstances that occurred around the time of your alleged violation, and certainly trying to get to the bottom of it. If for some reason that the HUD office is unable to complete its reasonable cause investigation in 100 days, you will receive notification from HUD letting you know that first, there's going to be a delay for an enumerated reason, and they will provide you an expectation and a timeline as to when your complaint will be addressed. And I think that's important because, again, you're in the situation where you found yourself experiencing housing discrimination. Is certainly not anything pleasant, and you want to have remedies, and you want to know that someone's paying attention and listening. So this process is set up just for that purpose. Once you receive, once it is filed, HUD has another alternative. They can provide you an option during the course of the reasonable cause investigation to enter into what's termed as a conciliation agreement. And this is an agreement that is signed off on by both parties, both the violator as well as the violated, to voluntarily resolve your complaint and move forward in a manner that is satisfactory to you regarding everything that has occurred related to the violation. If for some reason that option is not available or not selected, the next steps you can expect once the investigation is complete is that HUD will prepare a final investigative report summarizing the findings. If HUD determines that there was a reasonable cause for your discrimination, they will issue what's known as a determination of reasonable cause and a charge of discrimination against the alleged violator. That will be available and available for reference as you move forward. From that time, you will then have 20 days after receiving HUD's decision to decide whether or not you would like for your case to be heard by an administrative law judge, or if you would like to proceed to a civil trial in federal district court. And those options are available again to provide all the complainants with multiple avenues to resolve the harm that was experienced. Finally, I just want to make you aware of one additional outlet to seek assistance. At our office here, the Office of Legal Services within DCA, or the Georgia Department of Community Affairs, we monitor and evaluate the fair housing inbox, as we call it. This inbox is meant to provide, again, anyone who's experienced discrimination on the basis of their belonging or status in one of the protected classes to find information. We will help you with routing your claim into the appropriate venue, as well as answering general questions that you may experience as well. So do want to make you aware that in addition to the options here in Georgia, both at the state level as well as the regional office for HUD, that this option is available to you as well. We monitor this fair housing inbox, and you can expect to hear from a response in short order once this is submitted. You know, this box is intended, and I want to be clear, this box is intended to really provide another resource, and we're going to help guide and route you forward. We have staff members that we work with, because some issues may not fall squarely within the discrimination issue. We may find that there's a housing need and there's a frustration that came about because of those housing needs, and our inbox intends to provide resources and responses based upon the best options available. So with that being said, I want to thank everyone for their time and their participation. We've enjoyed speaking with you here this evening, and really want you to go away knowing that you have options, hopefully being armed with a broader understanding of the protections of the Fair Housing Act, as well as avenues to seek remedies should you encounter housing discrimination. Thank you so much.
Yes, thank you all very much for your attention tonight and for joining us in this. It's what we believe is a very important conversation. There have been a few questions that have come in while Joseph was presenting that we want to take a few minutes to discuss. One of which might be a little bit more specific. So we'll talk about the responses to that a little bit more broadly, but I'll start with the most recent question that we see. And the question is regarding the obligation of property owners to provide reasonable accommodations to make an apartment accessible for a walker or a wheelchair, and if we can discuss what some of those guidelines might be. So as you might have heard from tonight, there is an obligation under the Fair Housing Act for properties to be accessible. That's a part of the disability class of protected class under the Fair Housing Act. And the obligation for those properties and those property owners that are subject to the Fair Housing Act would be to provide a reasonable accommodation or to a reasonable modification, even if it's a physical disability, to the property. So you might have heard Joseph mention an example where someone might have been trying to discourage a disabled person from entering their facilities, or even being interested in renting or purchasing their home by saying, I'm not sure your wheelchair will fit here. The obligation to provide reasonable modifications is embedded in the Fair Housing Act. So if your property that you are renting or purchasing fits within the scope of the Fair Housing Act, then there would be an obligation for the property owner to allow reasonable modifications to the property for things like wheelchair accessibility. There are tons of accessibility documentations that you can find, mostly related to the Americans with Disabilities Act, and it will run parallel to the Fair Housing Act if you're being denied your access to housing as a result of a disability. So yes, the short answer to that question is yes, there are protections under the Fair Housing Act that would require a property owner or a landlord to provide reasonable modifications for someone with a physical disability to be able to access the property. Other questions that we've seen, and I'm going from the bottom up, so if your question came earlier, please know I'm going to get to it. The next question was whether there's a limit on the cost of applications to rent apartments. And this attendee noted that they've recently been seeing fees of around $100 for each member of the family to rent an apartment. Under the Fair Housing Act, there isn't an express prohibition that's related to rental application fees. If you can see that the fee is targeted towards some protected class, you might be able to file a discrimination claim under the Fair Housing Act, but you would have to be able to pinpoint that rule towards a specific disability. So if you're making the argument that my family has 95 members, such as I'm going to use an extreme example, so therefore my application fee is $9,500, and they're making it unreasonable for me to make this application because of my family size, that might be something that the local Georgia Commission on Equal Opportunity would look into as a discrimination claim. Or if you're able to say, only individuals within my disability group or only individuals within my race or color are experiencing this difference in treatment as a result of this rule, that might be something that can be looked into either at the state level by the Georgia Commission on Equal Opportunity or the federal government, and that's done through the U.S. Department of Housing and Urban Development, referred to as HUD, in their Fair Housing Office. So there is no express rule that says you can only charge a person X number of dollars as an application fee. What's acceptable in the industry would be acceptable all the way around, unless that fee is being charged differently because of your protected class, or there is some motivation that's being driven by your protected class. And then we have another series of questions that's regarding a very specific instance, but I will summarize this instance to make it more relevant for the entire group. So the question was, it was more of a comment that there has been some experience where an individual lost their Section 8 housing choice voucher due to a disability. So just generally, we would want to point out a few things about the requirements of the Fair Housing Act as it relates to Section 8 and the Housing Choice Voucher Program. So each federal program that would provide housing assistance similar to Section 8 or the Housing Choice Voucher Program is going to be required to provide you with a reasonable accommodation policy. You might remember from the earlier question, we talked about physical modifications to a property and that being a reasonable modification. For every other disability, if it's not a physical modification, maybe you need the change to a program rule, or you need some type of flexibility as a result of a disability, that's considered an accommodation. And through that process, there should be an outlined process for you to present your disability in writing and make a request of what it is that you need as a result of your disability to be able to access this program or this opportunity equally as if you did not have that disability. So for the individual that put the comment in the chat about this experience, you should know that there should be a way for you to access a policy on reasonable accommodations should you encounter this in the future. If you want to understand how to express a concern related to your disability and receive a modification to the policies, then the reasonable accommodation policy would be what you would be looking for. For this particular question, there were some very specific factors that were given, and there's some very specific outcomes that you experienced. I think you might be limited in how you can pursue your claim because Joseph mentioned there's some time delays. There's only a specific amount of time to produce your issues and to have the Georgia Commission on Equal Opportunity investigate or to have HUD investigate those claims. But it is definitely something that if you feel you've had your rights violated, you should explore whether or not those time delays have run and reach out to those avenues to have them investigated. I will say, and I should have said this up front, Joseph and I are both lawyers, but we don't provide legal advice on this call or this webinar. What we are doing though is providing factual information and resources that you can find if you were able to go online and search for this as well. So this information that we're giving you is from a knowledge place. It's from a place of other scenarios that we've seen that are very similar to this or that might be similar to in nature. But please, please, please don't take our word for it. You can absolutely go to HUD's website, to the Fair Housing, FHEO is the Division of Fair Housing and Enforcement for HUD. They can provide more information on the Fair Housing Act, as well as the eligibility criteria for them to investigate a complaint. And similarly, the Georgia Commission on Equal Opportunity, just searching that entity on the World Wide Web will provide you with several resources as well. And then lastly, from the same scenario that we've been discussing, another point that I want to mention is we at DCA do a lot of things to help our communities. And I believe there may be some housing challenges that might still be faced from the individual that was presenting this question. Please take the time to visit the DCA website. We are at www.dca.ga.gov. And that's www.dca.ga.gov. We provide economic development and housing opportunities throughout the state. We partner with a lot of nonprofits to provide homelessness prevention services. And we are one of the most funded organizations throughout the state to provide housing resources. So if you have a homelessness challenge and it's not in the city limits of Atlanta or one of the major metropolitan areas, we might have some resources to support you and to maybe even direct you to some emergency housing solutions. So take a moment to look at the website. If you're having trouble finding it, you can also email us at the Fair Housing inbox and we'll redirect your email to the appropriate divisions. I see that we had another question come through, so I'm going to see if I can't grab it. And I think that might be what we have. Oh, okay, so it's more of a comment than a question. But once again, at DCA, we are committed to providing housing throughout the state, and we are committed to educating our state residents on the Fair Housing Act, both at a state level and at a national level. So if you have questions about fair housing, remember, you can search those areas that we've told you about with GCEO or the HUD FHEO office, or you can email us at fairhousing@dca.ga.gov. I don't see any other comments, but I'm going to double check and make sure that there aren't any other questions. Checking the chat here, and I think I might have addressed them all. Joseph, I don't have any other final thoughts. Did you have any other thoughts for the group?
No, just thank you and wanted to echo all of Christy's comments. Thank you all for having us this evening. As she mentioned, here at DCA, we really seek to serve our community as a resource. So please avail yourselves of the Fair Housing inbox, but then also the resources both at the state level as well as the national level. And just thank you all for having us, and we really appreciate it.